Hello, everyone, and welcome back to Immigration and Jobs Talk Show. I'm really happy to be back again. And I'm Nipasa Pradhan. I'm going to be your host for this session today, and it's going to go on for an hour or so. So, before we go off with the discussion, I got this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, thank you so much for joining us. We are live right now on YouTube, LinkedIn, Facebook, and I'm very happy to tell you that you can also participate in this discussion and you may have some questions. And as you can already see, the topic of discussion for today is H-1B compliance in the Trump era. So, are you prepared for increased scrutiny? And we are definitely going to discuss about H-1B site visits, especially on this episode. So please feel free to comment whatever questions you have and to help us navigate through this very important discussion. It's none other than Attorney Justin Rivera joining us from Wasden Immigration Litigation. Thank you so much, Justin, to join us. How are you doing today?
Hi, I'm good. I hope everybody else is doing well. Friday, mid to late afternoon, close to the end of the day, so can't
Yes,
complain too much.
for sure, for sure. I was thinking we will not be able to make it today, but I'm so glad you are here. And
Yeah, my son may guest star at some point as a result of having to pick him up early from school, but other than that, we should be good to go.
we would love to have your guest, our guest star for today, but for sure, I'm really just glad that he's all right. And
Thank you.
folks out there, thank you so much for joining. We are going to discuss today about H-1B compliance in Trump era. So maybe you can just give us a few pointers what folks out there can expect today in this discussion, Justin.
Yeah, so I think this has got to be a pretty unprecedented event where you have an administration, a new administration coming in that is not the incumbent administration, but has previously served a term. So I think what we're really going to highlight today on the discussion is what were some of the things that were done previously by the Trump administration the last time that they were in control of the White House. What is it that we likely anticipate to be done moving forward, and how to prepare as an employer or even an H-1B beneficiary to deal with what is very likely going to be a more complicated next 4 years for U.S. immigration.
That's what, friends, we are going to be talking about today. A lot to discuss about, and 4 years is a long time. Right now, also, we are going through a lot of changes, and we are worried just about year 2025. So let's dig in and let's see what have we got for our future. And so, Justin, to help us, step into this topic, I got this first question. So, given the Trump's administration's history of increasing wage requirements for H-1B visa holders, what can we expect in terms of wage obligations in the future, and how will this impact employers and H-1B workers?
So I think inevitably you're going to see attempts that are made to alter how the H-1B process functions, just based on how Trump made some those sorts of changes in the previous administration. Obviously not Trump in particular, but Stephen Miller and those under his umbrella. I think in the past you saw things like the level one wage issue, which was something that came about during the very initial part of Trump administration, where basically they began just attacking any type of level one wage. Basically saying, level one is reserved for the absolute bare minimum entry level position into the field, and anything
Mhm.
that seemed like it was above that in terms of job duties, or job requirements, they would use to knock out those cases. So that right there is already something that I think it wouldn't be shocking to see, be rehashed or altered in a way where they continue to assault the lower wage levels as a way to make all wages go up overall. The other thing is,
Mhm.
hey, bud, you got to stop. You got to stop. I told you you can't do that. sorry. The other way that it's probably you're probably going to see changes is I'm sure they will try to introduce some level of new regulation altering
Mhm,
how the wage system works for the H-1B. They may either try to do that through the lottery, the H-1B lottery, by making the H-1B lottery weighted in a way by wages, where basically there's
mhm,
somehow a higher level of probability added to a higher waged position. Or
yeah,
they may try to redefine the scopes of the wages, basically saying, each leveled wage is actually a higher spectrum than it has been previously. So those are just a couple of ideas of what they could do. Overall, the big thing to say about how immigration law works, stop you, stop. The way that it works is this: if you want to create new law, obviously it takes steps. You have to take measures to either pass something, issue an
mhm,
executive order. A lot of times that's hard because it's subject to scrutiny at the court level, right? Eventually it can be
mhm,
challenged and overturned. What it's easier to do, and what I expect you're going to see a lot of done immediately because it was done during the previous administration when they were in power, is just a tightening of existing rules and regulations. I think right out of the gate, that's probably what you're really going to be looking at, is really curtailing and trying to use what's in place to limit the scope of what does and doesn't qualify. And so I think that's really where you're going to see them coming after pretty much everything that they're able to come after from an H-1B standpoint. But yeah, in terms of wages, it would not shock me if they attempted to make some sort of significant change over the course of the next 4 years to impact the program. And obviously, we have to realize if you're increasing wages, for the entry point into an H-1B, the people who are probably going to be hurt the most by it are going to be people who are trying to go into the lottery, people who are trying to get those first H's that are most of the time coming directly out of college. Because the problem, obviously, that begins to become for the employer, how much is too much, where it's just the floor to pay an employee is so high that it's just not worth it to actually employ that person, and instead we'll just find an alternative.
all right. So we can definitely expect a lot of changes and a lot of tightening. And since rules and laws cannot be changed overnight, but we are definitely going to see wherever they can make changes faster. I think we can expect some definite changes for sure. So let's look out for that. And thank you, Justin, for giving us a heads up on that, at least, so that we can prepare ourselves.
Mhm.
So now moving on, I have this next question for us, Justin, and this is: how will the Departments of Labor's rules on wage levels for H-1B and other foreign labor programs affect the hiring and retention of H-1B workers?
Yeah, so I think that's a great question. And I think that obviously it's impacted by what types of changes are going to be made to either the wage scale or, the actual full on change in the implementation of utilizing H-1B wages in a lottery type system, in a quota lottery type system. Like I was saying before, obviously, if the point of increasing wages drastically in the H-1B program is to make it restrictive. And that's the underlying goal, would be to have less people that are actually, going out and employing individuals on H-1B, because it just becomes cost prohibitive. So uh, obviously, I think it will have a negative impact. But at the same time, it's the way in which these policies are implemented that open the door for the possibility of litigation. We really, I know people will hate hearing this, and I think you're going to hear it a lot over the next 4 years. It's a bit of a wait and see. It's a bit of how do we look at what it is, because I mean, not not to be I'm saying this because it's just the truth. There's not really a lot of definitive information that's really come out there about Trump's immigration policies as it applies to legal immigrants, right? A lot of the things that have been capturing the attention of the media are in relation typically to people that are undocumented in the US. So that's going to be, things like the mass deportation idea, and then the idea of I believe birthright citizenship has seen a lot of attention recently. Now, the caveat to that is what is the implication of those issues, as they will subsequently inevitably relate to people that have legally immigrated? So what I mean by that is things like, we had seen in the previous Trump administration an attempt by them to basically say, if we deny you, let's say you're on an H-1B and you apply for an extension and you get a denial, we're going to issue an NTA, a notice to appear, because you're unlawfully present. Well, an NTA can be a leader to being placed into deportation proceedings. Coming on the back of this idea of mass deportations, do they then utilize that kind of program or that ideology to subsequently move against people that are on, legal status, who have their extensions denied and are then unlawfully present in the United States? So I think that there's going to be stuff that, in the moment when he says it's impacting, illegal immigration, it's still probably going to have an impact on legal immigration as well. I think the other thing to highlight too would be like the note, like birthright citizenship notion. Whether or not that's an actual thing that can be done is left up to interpretation. But hypothetically, if it were done in the way that he alleges it would be done, the idea would be that in order to qualify for birthright citizenship, you would either need to be one of your parents would need to be a U.S. citizen or a legal permanent resident. So that would subsequently mean that anyone that was in the United States on a non-immigrant visa, who has not had the opportunity to adjust status to a green card, that has a child in the United States, that child would not be a U.S. citizen by virtue of just being in the United States. Would be born and would not be, which is it's a crazy thing to even think about, because I don't even know how the long range implications of that work. Do you get a grace period to file for a visa? How exactly does that even make sense? But anyway, all of that is to say that it will have all of these changes that are being implemented are going to impact in a certain way people that have entered the country legally. And I know I kind of got off topic on that question, so I apologize. But I did want to make sure it was
No,
brought up in the discussion.
no, that was great, actually. Thank you so much for your insights and for your perspective, for sharing that with us. Thank you, Justin. Well, to move on, I wanted to quickly say hello to our viewers who are already participating. So, Christopher, we have Supriya with their questions. So, I think we will take up your questions, but just stay with us for now. I have a few more questions on my end, Justin. So, this next question is with regard to third party placements. So, what changes can we anticipate in the eligibility criteria for H-1B visas, particularly regarding the definition of specialty occupation and the requirements for third party placements?
Right. So during the Trump administration, they already attempted to make alterations for third-party placements. Right, there was the entire
Mhm.
issues with the memorandum regarding third-party placement requiring specific work examples. You would need to show work orders. You would need to show the full 3 years that there was specialty occupation work available. A litany of issues that were highlighted and eventually struck down by litigation. So that obviously fantastic that the end result was the removal of those things. However, knowing that third party placement existed as an issue during the last period in which this administration was in a position of power, it stands to reason that it will be something that they again look at to try to place some sort of barrier that makes the process more difficult. Currently, they are still bound by the requirements that came out of the IT versus CISNA litigation, which is, their prism is supposed to be specialty occupation. They're only supposed to be looking at, does the position qualify and does the person qualify for the position? So unless they're able to introduce new policies that allow them to specifically attack third party placement, they shouldn't really be capable of doing anything other than what they're doing presently until those new policies are released. Are those new policies possibly rehashing, under a different argument, the need to provide documents for third party placement or the need to show work available for a full period of time? Maybe. Or they may try to attack it in a different manner. That all being said, with what they can look at with specialty occupation and beneficiary qualifications, I think it's worth thinking about what I said earlier. The idea that they are going to tighten the existence of existing regulations. They are going to make it harder to qualify for specialty occupation. They're going to make it harder to qualify for beneficiary qualifications. How do they do that? So for specialty occupation, there's a couple of different ways in which you can qualify. There's 4 different ways to be specific. And in order to do that, you provide, evidence at that's supposed to meet a standard that subsequently allows the service center to approve the case. What we saw kind of during the Trump administration previously was basically invalidating the legitimacy of evidence by pushing a hurdle, by pushing something to an impossible standard. So what do I mean by that? One of the ways you could show specialty occupation is to say, hey, look, I have 15 software developers in my company, and all of my software developers need a bachelor's degree in order to do the position, okay? So I'm going to produce evidence to show you that. Well, back during the previous Trump administration, when you present that kind of argument, they would basically attack anything they could to invalidate it. Things like, well, that specialty occupation software developer actually does X, and this one does Y. So those aren't similar positions, or this guy is actually paid at a level 4 wage, and the guy you're talking about is paid at a level 2. That's not really the same position, or things like that, to basically push it to where it was very difficult, if not impossible, to meet the standard unless you really were able to stick to some really solid evidence. I wouldn't be shocked if there was a real uptick in the need for expert opinion letters pushing back against RFEs for specialty occupation, just because they're one of the strongest items of evidence that you can provide. So I wouldn't be shocked to see that. I think what you're going to also see is the kind of evidence that that you get away with now. Things like maybe articles, insight, professional insight, that kind of stuff is going to be lessened. They're just going to find ways to say that that's not legitimate and that's not something that actually shows the position qualifies. So I think that'll be a problem. From the beneficiary qualifications standpoint, it's going to be much harder to really say what qualifies someone for a specific specialty. And what I mean by that is this. I can remember before, during the Trump administration, that there was a litany of denials for people who had previously been having no problems getting approved with like an electrical engineering degree. Just something that was, somewhat related to the position, but the Trump administration was coming back and saying, absolutely not. If you're doing computer systems analyst work, you need a degree in computer science or IT. And that's basically it. So just the idea that you're really going to see that tightened, probably even further than it has been now, is something to be aware of. And so that does kind of get back to the idea of, do you just start getting those combo evals at the outset, those education plus experience evaluations, to then fit the person into the bucket that you want to put them in terms of, this is the specific type of education and experience they have that gives them this degree type. So it's a lot of times, I think now it's, well, we'll wait for the RFE. We'll see what the RFE is. I don't know if you want to wait for the RFE now, because if they catch you on one issue, they're probably going to do what the third thing is I was going to talk about with the Trump administration was the boilerplate litany RFEs, where they're just going to start hitting people with specialty occupation and beneficiary qualifications on every RFE. And it's just, the whole purpose of it is to delay the process, open the door for there to be more problems that could arise with the case based on what kind of evidence is provided. So I think people are going to have to adapt as a result. And we'll see, do they try and come out with a new definition of specialty occupation? We'll see. I think that would be difficult to do. I think they've had success in curtailing the definition as it is under the current rules. And I think what they're going to do is just continue to do that. I mean, if I remember right, I saw recently in an article, I believe the RFE rate generally for H-1Bs under the Trump administration rose something close to 20 something percent. I think it was 24, 25%. So
Yes,
if that's what we saw in the last administration, it makes sense that that's probably what we're going to return to, if
right.
not seeing higher levels.
Absolutely. And I think we also saw a lot of problems with extensions when they wanted to extend their visas. They were also facing a lot of problems. So we might as well expect that to happen even in Trump 2.0.
Yeah.
Right. Thank you so much, Justin, for explaining that in detail.
Mhm.
Now, I think we should.
Sorry for the noise if he's walking around in the background.
No, please do not bother. It's all right. In fact, if you want to take a break, we can have a quick break.
Yeah, if you wouldn't mind giving me like 2 minutes, that'd be awesome.
All right, so folks out there, just hang around. We are going to discuss further on H-1B compliance in the Trump era. So don't go anywhere. Stay tuned to Immigration and Jobs Talk Show. We'll just be back after a short break.
Just don't bang stuff.
Welcome back after the short break on Immigration and Jobs Talk Show. This is Nipasa Pradhan, and we have with us our guest for today, Attorney Justin Rivera from Wasden Immigration Litigation, and we are discussing on H-1B compliance in the Trump era. Are you prepared for increased scrutiny? And if you're not, if you have any questions, please feel free to comment them because we are definitely going to keep some time to take them up for you. Justin, thank you so much for being a part of this. It's been a great conversation so far. And we want to also know more about the scrutiny if we can expect on H-1B site visits. Do you want to talk about that too?
Yeah, absolutely. I think it's something that's going to be it's going to be problematic moving forward. I think that really right now there's probably going to be a familiar issue for people who are particularly handling third-party placement. I believe they're typically called, IT consulting companies, things like that. Right now, I think if you're an IT consulting company, you're probably seeing some level of site visits. Maybe it's not that bad. Maybe you're getting a couple a year, something along that line. I think that it's reasonable to anticipate that during the Trump administration, there's going to be a significant ramp up. Probably going to be done under the allegations of fraud. That there'll probably be some sort of idea put forward that, oh, there's fraud taking place in the visa system and we need to catch the fraud. They'll probably throw money into it to hire more officers, more FDNS site visit officers, in order to carry out these site visits. And as a result, I just think you're going to see a significant uptick. The thing about site visits, which we've talked about before, is a lot of times a site visit is used as a fishing expedition. It's an opportunity to come in and gain as much information about H-1B employees within a company as possible. So it's always common to see these broad ranging questions asked, things like, how many H-1B employees do you have? Can you give me a list of
Mm,
all of their names, all of their work locations, all of their wages? Um, what that really does for them is it just gives them an opportunity to then start looking through more and more information with the hopes, and I really want to reiterate, the hopes are that they find information to get cases revoked. That's what the FDNS officers are doing. They're not there to be your friend,
True.
and they're not there because they're just, verifying information. Their intent and purpose is to catch fraud. And the more fraud they can allege, the better it looks for them as an agency. So
So true.
if we were looking at a level of scrutiny that, let's say, was mild to medium during the Biden administration, I would expect a significant uptick. The reason for that is, I mean, it's pretty simple and straightforward. This administration wanted to restrict legal immigration during their last tenure. I see no reason to think that they're not going to be trying to do the exact same thing. One of the best ways that they can do that is by going to people's places of employment, doing site visits, and then trying to revoke H-1Bs with a finding of fraud. If you revoke an H-1B with a finding of fraud, that employee is inadmissible from the US and set up with a permanent ban. It's a great way, if you're trying to restrict immigration while still remaining within the confines of the law. So
Mhm.
I think that what we're going to have to do and what we're going to have to look at moving forward is an understanding that you need to have your employer and the H-1B employees set up in a way where they're able to succeed in the event of a site visit. Because you're not going to know typically when the site visit is occurring, and you're not
Mhm.
going to, most of the time, be prepared. And I think that era needs to go by the wayside because, in addition to issues with DOL violations for improper wages or placement or things like that, as the employee, the beneficiary, the holder of the H-1B, you're at risk if something happens. If something goes wrong where your case gets
Mhm.
denied with a finding of fraud, you're in a bad situation. And the fact of the matter is, the employer can typically walk away from it with not much of a penalty to them. Maybe they lose the employee, which sucks, but that's really all that's happening for them. So, unless there's really a repeated pattern of them doing these things, it's really not as big a deal for them as it is for the employee. That being said, for the employer, as I told someone who I had a conversation with earlier today,
Mhm.
when you get popped with an issue of fraud on an H-1B, you're basically opening the door for them to basically try and utilize that information across the board for any other H-1B employees. Um, you know, eh, what does this do to your other employees' extensions? Isn't as big a deal as what does this do when you go to the consulate? Because the problem you're going to also face as a result of this is at the consulate, I cannot see why they wouldn't start to issue even more 221Gs than they're issuing presently. And so, yeah, really, when it comes to site visits, you're going to have to be absolutely on top of your game with the information. I think it would be ludicrous at this point to not have legal representation when you're dealing with FDNS, because I just think it's too difficult to combat what the officers are trying to do unless you have someone there telling you what you actually do and don't need to require to answer, because they're not playing that game. They're going to, like I said, they're going to try and get as much out of you as you are willing to give them, and they will use every piece of information that they have against you when they can. And so, yeah, I mean, it's really incumbent on the employers and as well as the employees to really process what is happening, what is going to happen, and get ahead of that process by making sure you're
True.
prepared. And the
True.
last little thing I do want to say about this, because I've unfortunately worked on cases as a result of this very thing happening, you can have a site visit to your home. If your home address is a work location, like it is for a lot of us nowadays,
Right.
you can expect an officer to show up to your house.
Mhm.
That's something that people need to be prepared for, because I have seen horror stories where people have been working from home and, like myself, have their kid in the background and they're trying to
Yes.
answer an officer's question and they misspeak and say something wrong. And that officer, most of the time, isn't going to say, "Oh, hey, sorry, I think you said something wrong. What's going on?" They're going to
They're
say,
going to
"Okay,
use it against you.
report the information," and
Right.
then they're going to forward their report with a finding of fraud and a request that your H-1B be revoked.
I can only imagine. And it's happened. You said horror
Yeah,
stories, and it's not just one story. There's so many stories. So many people have been revoked because of this situation. And I think confidence also plays a very important role in this, the way you answer to these officers, or how timid you get, or how unable or nervous you become when these officers suddenly surprise you with their visits. Unexpected, right?
right.
And it's so scary that they note down all these, and they take your weakness and they just play it against you for their
Mhm.
benefit.
Yeah,
Crazy. But thank you so much. Yeah.
thank you. No, yeah, it's a tough situation to deal with when you're in it, especially if you haven't been, properly trained on what you're supposed to do and what you do have to say and what you don't have to say, and you know, the big thing too about legal representation is you can really just close the door on any line of inquiry right at the outset and explain that any level of correspondence has to go through your representative. And
Right.
that's when it comes into play that
Okay.
having that attorney representation removes you from having to make any of these difficult decisions in a moment where you're going to be stressed out. What it also does is it
Mm,
places you in a situation where you're eventually dealing with correspondence through email, which is great because then there's a record to show exactly what you've said, or you're doing it on the phone with your attorney present. And so in that circumstance, you're in a much better situation than you are if you're just handling the process by yourself.
there you go, friends. And it's always best to have your attorney with yourself who would answer most of your questions for you. Thank you so much, Justin. Much needed. I think folks out there and they have questions regarding this because, like you said, it's happening nowadays.
Mhm.
So let's move on now. I have this next question. How will My next question for you is what are the implications of the Trump administration's rules limiting H-1B approvals to 1 year for work at customer locations? And how will this affect IT services companies and other affected industries?
So for now, they're not really able to get away with doing that. What they had been doing in the past under the Trump administration is using those third-party placement memos. What they had done is they had basically curtailed approval notices to the duration of a work order. So a lot of work orders, they're typically going to be going till maybe the end of the year or maybe even the end of the fiscal year because they renew. And because they renew, even when we were responding to requests for evidence, we would be highlighting, just because this is the end date listed on the work order doesn't mean the project ends. It's subject to renewal. USCIS was ignoring that essentially and just saying, nope, you've only got that end date on there. So that's the validity period that you get for an approval. That has been invalidated by litigation. So it's not something that they're currently capable of doing. In fact, they actually cannot shorten a validity period anymore without giving an answer or a justification. Basically, because it's a partial denial, it has to be explained. So can they bring that back, I suppose, is kind of the issue to think about. And I don't
Mhm,
know how they would do it because I think they would have to get around the litigation that's already there saying that you
mhm,
can't. Because really how that issue came about was, like I said earlier, there's four ways that you can show a position's a specialty occupation. What they were doing was focusing on the fourth way, which is like the duties and the nature of the work is so specialized or complex that it requires a bachelor's in specific specialty. What they were doing was basically saying, oh, we have to know what these duties are. Otherwise, we can't tell if the position qualifies for specialty occupation. So we have to look at the work being done. And somehow they used that to justify that they needed the work orders. They did it with the employer-employee relationship in there as well. But it's all under this guise of specialty occupation because that's all they're really allowed to look at. So
mhm,
because that's been invalidated, I think that for now, I don't know how they would reasonably be able to do that, how they would be able to come back and shorten that. Again, I know, like I said earlier, you're going to hate hearing this, but it is a bit of a wait and see. We have to kind of see how they plan to implement that if it's something that they want to implement instead of being proactive in that regard. Um, like I kind of was saying earlier, though, just because they're not going to be able to attack the H-1B that way doesn't mean that they're not going to try to come up with new creative ways that exist within the confines of the current construction of the law to make the process more difficult. maybe trying to attack wage levels again, maybe trying to find ways to increase the wages in the H-1B. Again, really trying to tighten down on what a specialty occupation is. So I would say expect to see, all of that. But this may be something that they're not able to touch unless they're able to figure out a different way to do it.
Okay. Thank you so much, Justin, for the detailed explanation. And at this moment, Justin will take up this question from our viewer. This is on YouTube from Sandeep. Sandeep, Sandeep is asking, is there any chance of green card backlog reducing by passing some law? I have a priority date of 2016. Any chance of getting current in the next 4 years?
I don't want to hurt anybody's feelings, but I've definitely seen this idea floating around on social media that the Biden administration's inactivity, and their lack of desire to make substantial, meaningful changes to legal immigration merited them, going a different way in administration. What I mean is, the immigrants thinking, well, they're not doing anything, so maybe if we get Trump in there, he'll do something. I would be shocked and awed if the Trump administration took any act or did anything whatsoever with the end goal being of benefiting legal immigration in this country. I would love to be wrong. It would be amazing to me. But the fact of the matter is, the people who are in charge of the immigration policies that he's going to be, he's going to be putting forth, the people who are in charge of those policies, they want immigration restriction. They do not want immigration restriction purely within the ideology of illegal immigration. It is a totalitarian belief that immigration should be curtailed as much as possible. So why, if that is their goal, would they pass any meaningful legislation to benefit people that are waiting for a green card? I just don't know why they would do that. Again, I would love to be wrong. It would be awesome if I was wrong. It would be really great if Trump, for whatever reason, woke up and said, this is messed up. I have control of pretty much the entire government, the entire federal government, because my party is in charge of basically everything, and I'm going to help these people out. That would be fantastic.
Great. I know.
Could he do it? Yeah, I think he probably could. Is the other side of the coin. And that's where you start getting into what is the political benefit to him of taking that kind of action? And what is the rhetoric, the MAGA rhetoric he wraps that in to sell that to his own supporters? Because I'll already tell you just off the top of my head the way something like that would work. He would maybe introduce something that would work to curtail the backlog under the guise that the people who immigrated legally into the United States don't deserve to wait forever for a green card because it's not fair. Okay, that's a nice sentiment, in terms of this is unfair and we want to make it fair. His base will in turn very likely come back and say, why are you helping them? Why aren't you helping us? You're supposed to help us. Why are you helping them? What about my problems? Why does my groceries cost so much? Why is gas so high? Why is it so hard for me to get a job? So you do have to think about, you really have to think about why would he want to do this? What would he do? Why would this really help him in any capacity? And then looking backwards from that, look at the people around him, the Stephen Millers of the world, the Heritage Foundation, the people who really do immigration policies, and think about what they want and how he would be able to somehow spin this idea to them. So that being said, I would love to be wrong. And please, if I'm wrong, you can rub it in my face. Find me on LinkedIn and tell me I was wrong. I will tell everybody, each one of you, I will say, you are so right. I was wrong. I apologize. Congratulations on getting your green card. I would love for that to happen for you guys. I think it's an
Sure,
unrealistic.
Justin. For sure, for sure. But thank you so much. I think never better the way you explained it. And Sandeep, there you go. You have the harsh truth, but that is what it is. Thank you for your question. Thank you for participating, Sandeep. And now we have Jagadish on LinkedIn. I think we should take that up. Yes. Asking, is there a possibility to start the domestic visa renewal again?
So this again goes back to what do you think the Trump administration is going to do? And I think their underlying goal is going to be make immigration as difficult as possible while operating within the legal parameters of the law. That being said, I believe that the domestic visa renewal program was a pilot program that was being tested out where people were able to renew their visas here in the United States rather than having to travel abroad to do that. So
Mhm.
obviously, renewing your visa in the US was easier than traveling abroad. So no, I don't think it's going to come back. I,
Jagadish.
I,
Yeah.
I can't say it any more plainly than that. I think that you're going to have to go out of the country to renew your visa. You're going to see um, you're going to see more scrutiny at the consulate, and you're going to see more scrutiny at CBP because it's good. You're going to have multiple opportunities where they can check when you're entering and applying for a visa to see if there's a reason to deny you.
Mhm. Thank you, Justin. Thank you for taking that up for Jagadish. And I think we can take up Christopher's question now. This is with regard to RFEs. Yes. The Trump administration's stricter H-1B policies, what specific documentation and evidence should employers gather to demonstrate the specialty occupation's complexity and the beneficiaries' qualifications?
Yeah, so this is kind of where it gets back to what I was talking about earlier with I think that evals position evaluations that are from accredited professors at accredited universities or whatever. I think those are going to become big again because those were really one of the strongest levels of evidence you could have. I think you're going to have to really you're going to have to get real specific into the weeds about the job duties being performed for the per offered position. They're probably going to want to see things like percentages, which is a ridiculous notion. I've always found it hilarious that we're supposed to provide specific percentages for job duties as if I know how much of my day is spent checking an email or drafting a motion or reviewing a petition. But that's another thing that it wouldn't shock me if it comes back. Because what they were doing before was if you weren't providing percentages or 15 to 20 job duties, the argument became, oh, we're not able to tell if this position qualifies because we just can't really tell what this person's doing. And I had even seen that moved into the vein of, a professor does a position evaluation and they say, yeah, but the professor relied on these job duties and I don't know what he's doing in these job duties. So how did the professor? So, I mean, you're going to have to get really, really specific about what exactly the person's doing and how they're doing it. Again, you're probably going to need evals. The ONET and the OOH are basically gospel for USCIS. If you don't know what the ONET and OOH are, those are databases online that has employer information. The percentages related to the degrees, people that have degrees for that position, that's going to come back probably in a big way for them to say, oh, you're a market analyst. The ONET says only 30% of market analysts have a degree. So how do you qualify? So I think you're going to have to really start looking at what specialty occupation category are you in and how do you fit into that category? Because the other thing that they're going to push on now is pushing people out of the categories that have those higher rates. So let's say maybe a software developer is an 87% bachelor's degree on the ONET or OOH information. The other thing they're going to attack is this isn't a software developer. They're going to make this broad claim that this is actually position Y instead of position X. And so not only is this not a specialty occupation, but your LCA is deficient. So really it's going to be really having to hone in on the job, making sure it's in the right occupational category, and making sure that the duties are detailed and strict in how they relate to the position itself. For the beneficiary qualifications, I mean, you're going to be looking at them restricting it as much as possible. It would really shock me if unrelated degrees get through without getting an RFE moving forward. And by unrelated, they're really going to press it. They're really going to make sure it's very specific fields in relation to what's being done. That's where you come back with those combo evals, those education plus experience
Hmm.
evaluations. You have to be really careful with those because just like they try to attack the job duties for the professor eval, they're gonna try to go after those qualification letters as well. So there, when you're saying I have 5 years of experience at company X, expect them to start trying to come back with things like, "Oh yeah, we see that you said that, but we don't know what your duties were. So how do we know that this is a legit position?" Or that document wasn't on company letterhead. So how do we know that this is legitimate? I think I've even remember seeing in the past, and I'm not even joking when I say this during the prior administration. I think I remember seeing a case where it was signed and had all the information, but USCIS questioned the credibility because it did not have the signature information under the signature. So it was basically signed, thank you, John Smith. But they were like, where's John Smith's phone number? Where's his email address? And why doesn't it say his job title? So yeah, that's what I would say you could expect. And also, I'm sorry for the vibe being so down during this. I feel like I'm answering all of these questions really negatively. I'll try to find some.
Okay, let's take a U-turn. Maybe you could tell us what are the positive things we can expect then on this note, Justin.
Wow.
I know that's hard, right?
Yeah, that's a tough question to answer. You've put me in a tough spot.
Mm.
I mean, look, is there a world in which really because the focus of what Trump had been running on is purely in relation to the purported illegal immigration and border issues? Is there a world where that kind of gets the forefront of his attention and the brunt of his attention in the beginning of the administration? I think maybe. I mean, it's maybe possible that happens. But yeah, I don't know. I don't know how to find a real big positive spin on it. Just because I was practicing, I started practicing the first year Trump was in office. So all of this stuff was normal to me, and it wasn't until I got out of the administration into the Biden administration that I saw things and realized, oh wow, actually it was a little bit crazier under the Trump administration, just because the difficulty level was ramped up so high. So I would say, I guess the benefit of it would be this. Now that I think about it, and thank you for giving me a moment. The benefit is we've seen the administration before. There is some understanding of what had been done in the past, and I think that it will make it a little bit harder for them to make these changes in the future. A lot of attorneys practicing in immigration already have the experience under Trump's previous administration that we did not have before. We were having to create arguments whole cloth to combat these things that came up because they hadn't existed before. And we were able to find success once we were able to, get to that point where we found those arguments that worked. So I think that's a benefit, is that we are more equipped and prepared, I think, this time than we were before. Of that, you're not going to see as many denials as there was the first time the administration, the Trump thing is, litigation is a tool, and it is an opportunity to, go after the administration when they act in ways that just straight up. So yeah, I think they've been sued before and they've lost. And they moving forward, we know that. So it is tough when you take on Goliath. It is difficult when you face the government, but you can be successful. And I think that's important to know. It's not a hopeless situation just because it's made more difficult. I think more than ever, it's the employers that are willing and able to adapt and that are able to understand that standards may be enhanced, understand that difficulty may be higher, and they get ahead of it before it becomes a continuous issue for them. They're going to be in a position to succeed. I think it's the nature of the profession to be reactory and wait until something bad happens to then seek help. I think we have to be proactive, and I think we have to go ahead and start making sure that what we're presenting is stronger than what we're used to, with the understanding that it will inevitably begin facing a higher level of scrutiny.
Thank you so much, Justin. I mean, that was a real good perspective, and thank you for sharing that with us. I think we really needed to hear that.
Yeah.
Yeah. Thank you. So we have Sahil also, Pavan. Thank you for your questions. Stay with us, and I hope we can take them up shortly. But Justin, at this moment, I have another question, and that is, how can employers ensure compliance when H-1B workers are placed at customer sites, and what additional legal obligations might they face?
So when you have an employee placed at a third party location, that location is designated in your labor condition application, which means it is absolutely opened up to the scrutiny of an FD of a site visit. Site visits at third party locations, you lose power there, obviously, because as the employer, you're not physically present on site. So a lot of times in that situation, it's going to be kind of incumbent on the employee. The employee might have to be the one in that situation that's more properly trained and ready to respond to the inquiries that occur at that third party work location. Just generally speaking about some things that really need to be clear cut when you're placing someone at a third party work site in relation to the petition is their name. And what I mean by that is this. I know you're like, name, what does it matter? It's a silly thing. In your I-129 petition, there is one place for your name, and then there's a place below for any other names that you have or you may have been known by. If you are somebody who comes to the United States from another country, and because you're, maybe trying to assimilate, or because you've noticed that people have difficulty with your name, you say, just call me Jim. They all know you as Jim, which means if an FDNS site visit officer shows up and says, hi, I'm looking for Sahil, they may say, I don't know who Sahil is because I don't know a Sahil. I know a Jim, but I don't know a Sahil. Understand that that's literally all they need. They will say, okay, cool, turn around and walk out. Guess what? You're getting a notice of intent to revoke because they're claiming that you weren't working at the work site when they showed up. And when you say, well, I was working at the work site, they're going to come back probably and say, you may have been, but you didn't say in the petition that you were known by any other names. So how were we to know? All we have is the petition and the information in the petition to verify. So when it is a third party work site, I definitely think it's at least worth, as the employee, maybe just letting them know in some capacity, hey, if somebody shows up and they ask to speak with me, please let me know. Please come get me. If I'm not there, please tell them, hey, I'm out, and give them my email address or something like that. So that way I'm able to, communicate with them. The other thing about it
Right.
is, the other thing about it is, when they talk to these third parties, it can create issues with miscommunication. Perhaps the third party who has you assigned there as a contractor doesn't necessarily know how many hours you're working. Maybe
Mhm.
it's unclear what your actual job title is to them because they just know you as a consultant. So those are things where you really want to try to make sure that the information that's presented with you at the third party location, as much as possible, matches up with the information that's in your petition. Sometimes that's genuinely outside of your control. There's some things that you
True.
can't control, but it's always important to know that within the grounds of what you can control, you should do everything possible. And so that should be, letting them know about the potential for a site visit, letting them know how to get in touch with you, and letting them know that you want to be notified if and when a site visit occurs.
For sure, for sure. Thank you so much, Justin. And I think it's very important to be on the same page, especially when you have to deal with other parties and, the risk is you and your job. So you might as well try to communicate better, have your friends. I know not everyone is a friend in a world like this, but I think you will still have to try to be together in the same page so that you are safe, and make sure that you're playing safe. Basically, just that, doing the right thing, and being able to communicate properly is also much needed. That's from what Justin just explained. Thank you so much, Justin.
Hmm?
I think we can. How much? I just want to know how much time do you have? Can you stick around a little longer, or do you want to wrap up as quick?
I could maybe try to give you about 5 more minutes, but my son is being as quiet as he
I understand.
possibly can be, and
I
you know,
understand.
at some point, it's just not going to be tenable anymore. So,
I understand. All right. So our week, what since we have a lot of questions, and this is a very, very vast topic, and I'm sure folks out there also have so many questions. We can continue this in an for another episode. But before we go, Justin, if we can wrap this up in a good note, and also give us pointers to keep in mind, so that we are able to prepare ourselves for these coming days.
yeah, so just generally speaking, not to, incite fear because I'm not trying to, but I think if you have an extension that's pipelined, let's go ahead and get that filed now. Get it done now, sooner rather than later. If you need to go, for visa stamping and you have the opportunity, do it now. Any sort of thing that you have the potential to get done presently before January, late January to early February, I would get those things done, as expeditiously as possible, because it's always better to deal with what you know versus what you don't. And so
Yes.
I would just say, if you have that potential to do those things, do those things. That all being said, I think that, like I kind of was saying earlier, I think that the immigration community is in a much better spot in terms of preparation than we were back in 2016. And
Right.
so I do think that in order for them to really go after the H-1B program and H-1B holders, I think they're going to have to be more inventive and creative than they were before. So we are already on notice, basically, of the kinds of things that we were used to seeing, and we're
Mhm.
ready. I think we're more ready and more equipped to deal with them than we were before. I mean, really, honestly, like just the notion of even suing on denials. I remember back, before, it almost seemed ludicrous. This idea like, oh wow, really, we're going to go sue the federal government just on an H-1B denial? Like that was something. I don't know if those will become more commonplace as the denials get more outrageous, or if there'll be different avenues that'll be pursued. But that all being said, I just feel like we're in a better spot than we were before. And as a result of that, I am hopeful. And then obviously, with WASDN immigration litigation, you have John ready, to do what he does best. And I am ready to, handle those petitions moving forward, and ensure that we have the highest probability of approval possible.
Absolutely. That is what is required, I think. And folks out there, you can always contact Attorney Justin Rivera, have a one on one consultation, maybe consult with him regarding your case. And you can call him on his number. His number is 844-592-7336. You can note it down. And you can email him to get in touch with him also. And the email address is support@wasden.law, and go visit www.wasden.law to get to know more about Wasden immigration litigation. But thank you so much, Justin, for joining us today. It was really insightful. I wish we didn't have to wrap up as quick, but see, we've completed an hour and there's so much more to talk about. So I'm hoping to see you again soon, next week, maybe.
Absolutely, I'll do my best to be available.
Thank you so much. You have a
Mhm.
great weekend, and I hope your son is going to be superb very, very soon. I think he already
He
is feeling
seems
fidgety.
fine with me.
All right. Happy
Thanks.
weekend to you and your family.
Say bye.
Bye. So sweet, but thank you so much. I hope you're doing good.
Appreciate it.
There he
Bye.
is. Thank you. Thank you. Bye bye. Well, we've got someone saying you look like Junior Trump, Justin. Banda was saying that. That's just a view. But thank you so much, all you folks out there, for joining us. It was really great having you. And if you still have more questions, I'm really appealing to you to keep commenting, because, as you just heard, Justin is going to join us very soon again in the coming week. And we are hoping to cover all your questions and discuss further on H-1B site visits. Thank you so much for joining us today. Y'all out there have a great day ahead. And please do not forget to subscribe to Immigration and Jobs Talk Show and hit that bell icon, so that whenever we have discussions like these, you are notified. Thank you for joining us. Have a great weekend.